Welcome to Brief Encounters and to Season 2 of the Securities Regulation and Enforcement series. My name is Valerie Mirko. I'm a partner at Armstrong, Teasdale, and I'm also the leader of the firm's Securities Regulation and Litigation practice. And with me is William Nelson.
Hi, Valerie. William Nelson. I'm the Public Policy Director and Associate General Counsel at the Investment Advisor Association, and just really, really excited. We're, knee deep into season 2 now.
We are. It's amazing how quickly time goes by. And we're recording this just a couple of days after Paul Atkins was confirmed by the Senate as the new SEC chair. And this episode will be out on April 23rd. And William, I think we both expect that at that point, Paul Atkins will have been sworn in and will be starting to hire senior staff and move forward with some of the priorities that we've seen during this transition.
Yeah, absolutely. And I think that's absolutely right, Valerie. And again, we have white smoke. We have an SEC chair, so that's very exciting. Looking at incoming chairs, Atkins' former history, serving as a commissioner for several years, also his work outside at a private firm as well. I think, Valerie, we're going to see Commissioner Atkins have a real focus on cryptocurrency, digital assets. That's something he did in his private practice. We've seen the administration really have a high priority also on cryptocurrency. I think we're going to see a lot of focus on public companies. That's something that incoming Chair Atkins has advocated for in the past, democratizing investments, ensuring that we have a robust public market, getting those firms to go public. And I know that's something that Congress is also focused on as well. So I think there'll likely be some joint movement there, and they're going to work together. And, I think that also, one of the things we're going to see is, definitely, and this is more in your wheelhouse, but, I think we're going to really see, a pretty big sea change in enforcement. And, I was hoping, again, you're the expert here, that hopefully you could talk about that.
Of course, of course. Before I jump into enforcement, on the public company front, one of the nice things about looking ahead to Paul Atkins's tenure as chair is he was a commissioner in the past, but he's also been a thought leader in recent years. And something that's come up pretty often with him in the last couple of years is he has noted the risk of information overload through too much disclosure. So when we're talking about the democratizing of more public companies, I think we're also going to see just a recalibration of disclosure heavy requirements, particularly in the context of public company disclosure. But let's move to enforcement. And thank you for bringing that up, William, because that's something I've been watching very closely. I think we're going to see a genuine return of SEC enforcement focusing on investor harm and really moving away from, whether it's foot faults and broken windows or whether it, which we saw about 10-ish years ago. And then more recently, those off-channel communication cases that ultimately did not have investor harm. So I think we're really going to see a renewed focus on enforcement matters that have investor harm, where there's actual fraud, a focus on repayments and reimbursements to investors. And we're just going to see less of these smaller violations that can be resolved at the exam level if it's an investment advisor or broker dealer, or frankly would just never have made it to enforcement 10 years ago or 15 years ago, but we're starting to become increasingly enforcement type case theories in recent years.
Yeah. And Valerie, I think that's absolutely right. And, you kind of hear, all these terms being thrown around, going back to the SEC's core purpose, the bread and butter enforcement cases, fraud, deceit, misinformation, misleading investors. So I think you're absolutely right that there is going to be kind of that going back to basics, and this is, something we've heard from the current commissioners, including, Commissioner Peirce, Acting Chair Uyeda, just kind of getting back to those basics, but still obviously ensuring that you have a very strong compliance program as well.
And those basics are very important, like we're going to get later in this episode about sort of some of the deregulatory actions of the second Trump administration and their impact on the SEC. But certain fundamentals are not going away, particularly things related to compliance, valuation, billing, disclosure. These things are the back to basics that we keep hearing about from current acting chair Mark Uyeda and from Commissioner Peirce. Like that will not change even in a deregulatory climate, because that is in a lot of ways the foundations of our financial markets and of relationships between American investors and their investment advisors and broker dealers. So I do not see that changing. Another thing that I do not see changing, especially since we've just mentioned fees and disclosure, is the ongoing focus on issues such as mutual fund share class disclosure. There are still mutual fund share class matters happening, both at the exam and the enforcement level. This is something that started to really accelerate during Jay Clayton's term as chair, and he put a lot of focus and resources on share class. And it continued during Chair Gensler's term, and I think it will continue now during Atkins's term as well. So certain things will stay the same. Other things when it comes to enforcement will be recalibrated. We spoke in the last episode about the authority to issue a formal order of investigation no longer being with the director of the enforcement division, and that having gone back to the commission. I think what we'll see is enforcement leadership having more dialogue with the commission earlier on when an enforcement investigation is started. Of course, we'll see voluntary requests. We'll see investigations begin without a formal order. That will still happen. That will happen, rather, under this new framework where a formal order can only be issued by the commission and no longer through delegated authority. But I think when it comes to novel case theories, those are going to benefit from commission feedback much more early in the life stream of the investigation. And I think that will be key in seeing some changes in priorities as well. What we've seen the last few years is novel case theories occurring more at the staff level and the enforcement leadership level, but the commission not really being involved until it's time to go over, the recommendation memo and the settlement. So I think that's where we'll see changes. Novel case theories will benefit from significantly more higher level input, meaning commission input earlier on.
Yeah, no, and I completely agree with that. And again, kind of business as usual, again, and I think in this environment, I think that should give comfort to firms, that they are still, the cop on the beat, looking for those types of issues. But, I know you had mentioned, Valerie, kind of, this, potential deregulatory environment. And interestingly, that you bring that up, just last night, we did have a new executive order. They're coming out fast and furious, basically directing all agencies, this would be including the SEC, to repeal what they see as unlawful regulations. And they point to recent Supreme Court decisions, basically reducing the size and scope of what they call the administrative state, and basically directing agencies to rescind those regulations without going out for notice and comment. And again, for the policy wonks like me that have to be steeped in the Administrative Procedure Act, generally when you go out with a rule proposal, you propose it, you go out to the public, you receive comment, finalize based on those comments, and then you have a rule. But the Administrative Procedure Act does include what's called a good cause exemption, that would allow you not to go to a notice and comment period if the process is determined to be impracticable, unnecessary, or a contract to the public interest. Now, while that's pretty broad language, historically, the good cause exemption has been really limited to, national emergencies, could be national security, could be trade, environmental regulations that need to be set up quickly. So it is going to be, very interesting to see, kind of how, in addition to the previous executive orders we've discussed on, removing, 10 rules if you propose one and, reviewing rules that are in place, just kind of this, these aggregate executive orders, how Chair Atkins will navigate that, when he comes in, being confirmed already, but when he comes in over the next, week or a few weeks.
I think that's right, especially because Atkins, when he was commissioner about 20 years ago, was pretty outspoken about the importance of smart regulation, considering new rules as aggregate burden as opposed to being considered on a standalone or siloed basis. So I think there was already appetite, regardless of the executive order, for the SEC to really take a closer look at some, especially investment advisor rules. There's been a lot of rules in recent years. And at the end of the day, there is a significant segment of the investment advisor industry that are not very large firms, even if they might manage quite a bit of assets. They're still, we're still talking 15 to 30 person firms who just do not have the resources for, multiple rulemakings within the same, couple of years. So I think there was appetite at this new commission level to really look at the aggregate burden. I do think the executive order you're citing, William, is just going to accelerate that.
Yeah, no, and I think you're absolutely right. And, I think there will be litigation like there have been on some of the other executive orders. There will be pushback from, some parts of the industry or potentially consumer groups, depending on obviously what the rules proposed for repeal are. But, I think, coming into this kind of environment, I think it does give comfort to a lot of registrants having someone like incoming Chair Atkins who has sat in the seat before, who, we see, as an institutionalist. But I think it might also be interesting just to kind of look back over the last couple weeks, couple months, and acting Chair Ueda's tenure and kind of what he was able to accomplish in those couple of months.
And he accomplished quite a bit in just a matter of several weeks. And some of it, I think, there's really two factors. One is, as of January 20th, around 1 p.m., the commission had flipped already to being a Republican 2-to-1 commission. That does not always happen when the president is inaugurated. There's sometimes a sort of 2-2, two Republican, two Democrat commissioner, almost stalemate. There's only so much they can do at that point. So I think one factor for acting chair Uyeda is he did have sort of an immediate Republican majority commission. And secondly, the second factor is both Commissioner Peirce and acting chair Uyeda worked closely with Paul Atkins 20 years ago when Atkins was then a commissioner. So I think philosophically, there is a lot of alignment between them. They're all institutionalists. They're all very focused on both investor protection, but the health of the financial markets as well. They've all generally been proponents of smart regulation, taking a look at aggregate burden. So a lot of the consensus building that sometimes needs to occur between commissioners has a lot of groundwork already taken care of. So I think as a result, acting chair Uyeda was able to move very quickly, particularly in terms of crypto, but then also putting out a good amount of policy guidance, both about crypto and beyond that, And William, I was hoping you could speak a little bit to that.
Yeah, absolutely, Valerie. And I completely agree. Just the kind of confluence of events, having that flip, kind of having that alignment, on policy, I think definitely allowed them to kind of hit the ground running. As far as crypto and digital assets, we've, seen multiple pieces of guidance, some relating to what they call meme coins, others related to what they call stable coins, which are theoretically backed one to one with some type of a reserve asset, generally, the dollar or other cryptocurrency. We recently saw guidance related to crypto and public offerings, just basically providing guidance for those firms on, how they may, and this goes back, Valerie, to your point about incoming chair Atkins likely focus on public companies and having a robust public market, basically giving them guidance to allow them to complete the IPO process. We also saw guidance on the marketing rule, something that I know a lot of industry members, including the Investment Advisor Association, had been asking for, and also public companies. We had guidance on proxy guidance. We also had guidance on different reporting requirements for investors when they would need to submit certain forms depending on what percentage of holdings they own of a company. So, I completely agree. I think Acting Chair Uyeda has had a very busy tenure, and now with incoming Chair Atkins, holding the reins, I don't think that's going to slow down, even with this potential deregulatory environment.
No, I think that's right. And then, of course, the other thing that's been happening is significant attrition amongst the ranks of the staff. And William, when you and I were chatting before we started recording this episode, we were both remembering that during Jay Clayton's tenure as chair, there was significant attrition then. The difference was that occurred over 3 years as opposed to 3 months. And second, the attrition was not necessarily at senior career SEC staff levels either, whereas we're seeing that now.
Yeah, and that's definitely something that, I think there is some concern. You're absolutely right, Valerie. I think the speed and breadth of this kind of, Doge effort can be concerning just when you see, those kind of, eye-popping numbers, 500 to 700 staff, 10 to 12% of the SEC's workforce. So I think that that is something we are concerned with. We're very supportive of a well-funded, well-supported SEC. We definitely want them to, as we talked about earlier, focus on that investor harm, get the bad apples out of the industry. So we do share the concern that with this kind of Doge effort at the agency that they could lose, as you noted, a lot of senior staff, which may not have happened without this effort, and which as you correctly stated last time, it was more of the non-senior staff that headed for the door.
No, I think that's right. And there is such tremendous institutional memory and knowledge and expertise within SEC staff. And that's frankly one of the strengths, not just of the agency, but it's foundational to the strength of our capital markets, that there is so much expertise in the building, so to speak. So, listen, I think we all want regulations that consider burden. I'm a big proponent of smart regulation, but to do that, you also need the expertise. So I think it's going to be a balance, and I think only time will tell how it will evolve and play out. But in the meantime, a lot has been accomplished from a policy standpoint, despite the attrition.
Yeah, no, and I completely agree. And, I definitely commend, Acting Chair Uyeda, Commissioner Peirce, and all the staff on all of their great work. But, Valerie, it's just going to be really interesting. We've obviously seen market volatility these past few weeks, mostly related to tariffs, but also with this Doge effort. So I think, incoming Chair Atkins is coming in at just kind of a very interesting time, which, as you correctly pointed out, we've had similar, obviously, market volatility in the past, but I think I don't know about you, but this time just does feel a little bit different.
It does. It truly feels like an inflection point, both for the commission and the staff, but also in terms of the context, the larger context in which they're functioning and everything that's happening with tariffs and uncertainty. So, I think this is one of those things where when we look back on this episode in a few months, we'll see what the shelf life was and where, how much did we see into the future versus how much we're watching it unfold and commenting on it.
Exactly. Yeah, and I think that's one of the, I guess, fun but also sometimes frustrating things about these episodes is we record it and then 2 days later, we have some, huge event either with, a change in the government or another, executive order. So yeah, it is really an interesting time to kind of be in this industry, but also, doing what we're doing, providing, the most up-to-date relevant information to our audience, but at the same time knowing that just with the speed and breadth of these changes, it is really just fascinating.
It is. And, looking ahead to future episodes, we are going to have some more guest speakers on future episodes. We do want to talk more about artificial intelligence, the impact on the industry, as well as changes in crypto. So more to come. And I guess till next time.